we will get started. It's all you, Katie.
Okay, thank you. Good evening. My name is Katie Brown, and I have worn a bunch of different hats that kind of touch on this. I currently am a legal liaison for DCYF covering Region 5, but I do need to add, I guess, the disclaimer, I'm not here as a DCYF employee. These slides are not DCYF approved slides. I just have to say that as a state employee. Um, I am still currently, I am currently a DCF employee. I'm also a board member for the Washington Association of Child Advocate Programs. So previously, the director of that program had been planned to be the speaker, but now you get me. And then I also supervised and ran a child advocate guardian ad litem program for about 8 years in Walla Walla, Washington. And before that, I was also many, many years ago a CASA volunteer in King County. So that's just a little bit about my background and who I am. Oh, and I worked for the Alliance for a year. So I also did that. Sorry. Last but not definitely not least, was a coordinator with at the Alliance. So that's a little bit about me. And my hope for this evening is to give just kind of a high level overview of um, pre-court intervention, court intervention, um, why we're intervening, what the intention is of the intervention, who is involved in court intervention, and just some different options, trying to answer some kind of frequently asked questions, and then we'll have plenty of time for Q&A. I've been in a tort trial for a month, so I haven't actually ever delivered these slides. So I have no idea how long they'll take. I'll try not to talk too fast. But again, please feel free if you have questions about what I'm talking about, because some of this, like, court is complicated. Please feel free to put that in the chat, and Luann can ping me so that you don't feel like you have to wait till the very end. Okay, so I guess that means I have to share my screen again. Hopefully. Okay. Can you see my PowerPoint intro? Yes. Okay, great. Okay, so first I just wanted to read a couple of terms that we're going to use. I'm not going to go into too much depth of these just because we're going to talk about each one. But many of you may have already heard the term VPA or a voluntary placement agreement. So we are going to be talking about those, and it really is what it sounds like. And so this is a pre-court intervention where it is voluntary for the parents to place their child either with a relative or if there is no relative available in foster care for up to 90 days. We use the term services a lot, and that's a very vague general statement. And when we're talking about services, it can mean anything from mental health counseling, parenting assessment, drug and alcohol evaluations or ongoing support. So activities, I guess, and interventions that include a professional that are designed to, at least for the parents, help remedy those parental deficiencies. Services for a child might include additional or specific educational support, maybe some specific emotional or medical therapies, counseling, OT, PT, those sort of things. But the term services gets thrown out a lot. One thing that is absolutely not a service is visitation between parent and child. That is a legal right that they have. And so that's not included when we talk about services. You'll hear guardian ad litem or a GAL. You may also hear the term CASA or a child advocate. Those are all interchangeable for the most part, more or less the same thing. And we'll talk a little bit more later about who they are and what they do. Imminent physical harm is a complicated one, but with new changes to the law, that definition comes up a lot, and we'll be seeing that as well throughout some of these conversations. Um, and the way we at DCYF, and probably the child advocates as well, think of imminent is, you can't walk away from it right now, right? It's very different than the threat of something that could happen. So I think there's one example might be, driving in a car without a seatbelt. There is definitely a threat. There is the possibility that if you get into an accident, you might have greater injuries than if you were wearing a seatbelt. But that's different than imminent physical harm, which is you are about to get into a car crash unless if you don't hit the brakes, you're going to hit that car, right? And so that something that is going to happen. Someone can see it. It is not really up for dispute. PC is another term that we use often, and that is police custody. And so that would be when law enforcement uses its own set of rules that pertain to very specific laws for them to remove a child from parents' legal custody. Sometimes that gets a little blurry or foggy because they're giving them directly to CPS generally, but it's their authority and they're the decision makers. So police custody, again, will come up later. Shelter care is a term that gets thrown out a lot. And again, we'll talk about more of what that is, but just I think the key thing I wanted to share with this terminology of shelter care is it really refers to the legal status of a child being removed from their home. So we'll see it used as a term describing a specific court hearing, but it's also very specific in that for a child to be, quote, in shelter care, they have to be outside of their parents' care and custody. The other one that will come up often is ICWA, is how we pronounce the ICWA, and that refers to the Indian Child Welfare Act. And we could spend hours and hours talking about that one. But those are very specific federal rules. We also, and laws, and we also have Washington Indian Child Welfare Act, so WICWA, that guide us and direct us for different and additional there's additional protections for children who are designated as Native American or American Indian. And again, that really drives the efforts that the state is required to put into maintaining that family unit, as well as timelines. And so it definitely adds some additional challenges to the whole picture of the case. Any questions or any, again, I only picked, seven words. Are there any other terms that maybe or acronyms that anybody wants to ask about real quick? If you think of something as we go along, let me know. Okay, so this is just a quick, I don't know if it's quick, but just a little visual aid to kind of show you what the process is kind of leading up to any court intervention. So we'll start on the far left, right? So if there are allegations of abuse or neglect, see a little typo, are called into the CPS intake hotline. And so that's usually what gets the ball rolling, right? Even a state social worker, if they have new information on a child or family on their own caseload, they are still required to call it in to the hotline. So that Washington State, you always have to start here with this hotline. So if there's enough information provided to the intake line, then they will initiate an investigation. And sometimes there really just isn't enough information. If someone doesn't really know the family very well, they didn't actually see any injuries, they don't have any idea how long ago it was, then it may not rise. There may just not even be enough, or it may be clear to the receiving caller that it's not worth an investigation. If upon investigation they decide that there isn't, again, enough for further intervention, they may just offer some optional community services to the family. So that would still be a social worker working voluntarily with the family. So it's voluntary for the family, right? And they may just say, hey, it looks like there might be some challenges here. And that could be helping them get on, maybe connecting to EBT and some financial support from the state. It could be helping if if the family is interested in getting the child into daycare, helping facilitate some of that, helping maybe get some just concrete goods. So concrete good could be a pack and play or a new car seat. So some small interventions that because they've determined that there isn't an immediate threat to the child, that maybe there isn't a safety concern, but maybe there are just some issues that the family is struggling with, and they're willing to have some support. So that would be one response. And again, it's completely voluntary. We have plenty of families that want nothing to do with us. We cannot threaten them by saying, if you don't do this, we're going to take you to court. And so families may or may not participate. And if they say, I don't want to talk to you, I'm not interested, then in those circumstances, we're required to close the file, or we may just monitor them. But again, there's no obligation, there's no legal requirement for the families to respond to our phone calls, to let us in the home, if again, the allegations don't rise to the standard of a more intense investigation. If it looks like there is some enough substance here, then we're going to again deepen our investigation to see, is this child in imminent danger? And this is all happening behind the scenes, right? The social worker is doing a whole lot of collateral contacts, and this process can all be lengthy, depending on the information that needs to be gathered, or it could also be very quickly. I will say that this isn't my forte. I do more of the quick stuff. So if you have questions, I'll do my best to answer kind of what happens behind the scenes. But since this training is more in court, hopefully we'll get through this part together. So again, they are investigating, is the child in imminent danger? And again, that standard in the law has changed over the last few years. So if you've been a foster parent for a long time, or if you know families, you will know that there has been a significant impact to the legal threshold in terms of when you can remove a child from its family, from its parents. And so there has to be evidence of imminent physical harm to that child, again, meaning you cannot walk away right now. Like if you left the home right now, this moment today, absolutely something is going to happen. And that is really challenging when there's a whole lot of what ifs and maybes, and there is high concern, or there is definitely, like, the threat is very real. So there are a few options at that point. We can again offer services. They would be voluntary. We could offer, hey, why don't we help you get your child into daycare to give you a little bit of a break? We might be offering to help support them if they're interested in getting into substance use disorder treatment, or engaging in some mental health services. So it would kind of be more like voluntary case management at that point. Maybe, having meetings and bringing in family members, trying to see if there are avenues for, again, in a voluntary capacity, putting some extra family members or friends into the home to try and mitigate any safety issues. And again, that threshold is really high in terms of when we as the state can intervene. And I know that can be really frustrating especially for family members, when they see a loved one, the adults who are abusing substance uses, and there are small children in the home, and they feel like they're calling in and they're asking for help, and they feel like the state isn't doing anything. And so again, there will be times when the state's going to try and really lean on family to help keep the child safe in the home because we don't have the legal capacity, or not capacity, the legal threshold necessary to succeed in having the court give us permission to remove the child. So that kind of gets us through the three columns. And then I guess at the very end of the third column, right? So we can offer those services. The other thing that we'll move on to talking about is the voluntary placement agreement, because I know that that is something that many of our kinship caregivers are asked to consider. And with a voluntary placement agreement, again, we're looking at a short-term intervention, and we'll talk about that some more, but that's still no court intervention. So there are no attorneys involved. There's nothing forcing or holding the parents accountable for any behavior changes. And it's not going to do anything to prevent any immediate safety issues for the child. If the parent, well, sorry, I misspoke. The intention is that it would, if you have that voluntary placement and the child is removed, then it would provide a little bit of time to kind of sort things out, but it doesn't, again, hold the parents accountable for following through with those. So if we've tried to offer either a voluntary placement or just services in a voluntary capacity, or perhaps there's no time for those. The safety issue is right now they're in imminent danger, and we don't have time to offer those efforts to make efforts to try and keep the child at home. Then that's when we would file what's called a petition for dependency with the court. So up until that point, we may be trying with this family to be able to keep the child in the home while also safe. But when we reach that point where it's just not working, then that's when we're going to file that petition and move into court involvement. Okay, so I did touch a little bit on the voluntary placement agreement. So parents voluntarily place their child into DCYF custody. They still maintain their legal rights. They still have decision-making authority. They don't have any legal counsel. So there is a process now where they can receive free legal consultation, just so that they understand what a voluntary placement agreement is, what the expectations are from the department. The department's still going to be offering services, trying to encourage that family to get into mental health therapy or substance use disorder counseling, or whatever it is that is creating that harm to the child, and also coming up with a visitation plan when they would see the child, if there needs to be supervision, what that looks like. But again, it has to be all agreed. This is designed for cases where we think this can be resolved maybe within 90 days. The law allows up to 6 months, but our DCYF policy is for 90 days. And then if we think that we're really on the cusp of being able to leave this family without intervention, then we might extend. I have to say it's not the most successful intervention that we have. 90 days isn't very long for families that are really struggling with either mental health or substance use disorder. It can be helpful if we have, or useful and I guess successful for families or a parent who is demonstrating a willingness to engage in services, say they're willing to go into treatment, and the treatment has blackout period. And so the first month they're not allowed to have their child placed with them. This could be a good opportunity to put the child somewhere that's safe, that provides some safeguards. We're again, kind of case managing, helping the parent get into a program. And then if it looks safe, placing the child with them in the home. So that might be one example. Or if another parent becomes incarcerated and it also looks like it's going to be very short term and there's no other family members available, right at that time, or we want to have, again, some structure to it. This could be another option or opportunity to use a VPA. Um, the thing that is also challenging with a VPA is that a parent can terminate their permission, the voluntary component of it, at any time. And as soon as they do that, it can be by text, it can be by phone, it can be verbal statement to the social worker. We are required to then return the child to them within a reasonable period of time, which is usually defined as the same day or very close to the same day or the next day. So it's very quick. So that the state will often be prepared to move to the next step, which would be, again, that filing of that petition for dependency. Anybody have any questions on the VPA? I know that was pretty general. Nope. Okay. So what is a dependency? Dependency is a legal designation. And what it does is it gives the state the care, custody, and control over the child. This whole thing is a court process. And because it is a court process, we have a lot of rules that we have to follow. Do a training with our social workers talking about just even our general court system here in the United States and how it is common law. And it really is designed to be adversarial, and it is designed to have parties kind of pitted against each other, and whoever tells the best story is determined the winner. And that is unfortunately still more or less the system that we are working in with independency. It does not mean it can't be collaborative, but the bottom line is this is how attorneys are trained, and this is a system that America has created for us. And so it does add a lot of challenges when we're not just looking at, one side good, one side bad, criminal and defendant. We're looking at actually a family and how do we keep keep children safe and try and reunify families. And so it's a tricky puzzle piece, I guess, to fit in there. But again, we do have very um, strict federal rules and guidelines. We are um, tasked with following the Federal Child Abuse Prevention and Treatment Act. We have a lot of state rules as well. So things that don't make sense, it's usually because it's some legal rule or quirk. The other piece with the dependency is it may or may not include out-of-home placement of the child. So we can still intervene, we can still request a ruling from the court, but it doesn't always require the child to be out of the home for that. And that's also a fairly new practice here in Washington State. It's always been allowed under the law, but that wasn't something generally that DCYF was interested in or agreed to. Kind of the line of thought was, if we need to intervene at this level, then it's probably because the child isn't safe in the home. But what we are finding with again, the changes in the law under House Bill 1227, that really upped our burden of proof, especially around high potency synthetic opioids, and the laws really working hard to keep families together, that the courts are not always willing to grant out-of-home placement. And so we will still ask for court intervention while the child is still at home. And then again, that can be kind of a confusing process for everybody involved. Okay, so what does it look like when we are initiating the court process? So we file a petition. It's a multi-page document. And again, as I said, it may or may not include a request to take the child into custody. For the most part, it will. But on some occasions, we will agree that with what we again would call certain conditions, the child could remain in the home. And that may be that we are asking the court to require the family to allow us to be in the home multiple times a month. That we are going to stop by unannounced and they have to let us in. That they would sign releases of information. And those seem like really basic things, but under the court process, normally, parents may not have, like, they still have these legal rights and they still can say no to things. And so when we're making certain agreements with the court, we're trying to get at least some basic authorities um, to allow us to have some sort of level of intervention. So as I said before, we may file that petition even if the child is in a voluntary placement agreement. And again, that's because either we think we're running out of time and there hasn't been sufficient progress with the parents over that period of time, or perhaps the parent revoked the voluntary placement agreement. So again, we have this really long document and we have to be very specific on what, what proving how this child is in imminent harm, there's in danger, imminent physical harm. We have to show a causal relationship between the home conditions and that threat of harm. We have to prove that there aren't any services or interventions that could mitigate that threat. And that the threat outweighs the harm of removal. So those are all pretty significant things that we're having to, again, show the court that we've done a lot, we've tried really hard, that this is kind of a last-ditch effort, or that the safety threat and the danger is so high that we had absolutely no opportunity to try and work with the family in a voluntary manner. And that's really hard. These petitions are really hard to put together because sometimes you're putting together like years of information or lots and lots of facts for the judge. And the social workers are social workers. They're not always really fantastic at translating into judge language. So that's part of my job at DCYF, is helping them with that. And they're also working on a time crunch. We have 72 hours to get in front of the judge if the child has been removed by protective custody from that police protective custody, right? Or if we have already requested a pickup order. And so those are the two ways that a child can be removed from the home. It can only happen by a court order, or at our request, or through the police intervention. We do not have the authority to remove a child from their parents without one of those two things. And that can be challenging for us sometimes too, when there are disagreements between ourselves and law enforcement, or ourselves and the judge. So it's possible that, again, the child is in the home and we are not able to get permission to remove the child before that hearing. So there are times when we show up to what is called either a 72-hour hearing or a shelter care hearing, and we are at that point asking the court for the authority to remove the child from their home. Okay, so this kind of gives us a big overview, and then we'll shrink it back down a little bit. So again, on the far left, we have the pre-court involvement. So that could be that CPS referral coming in from the hospital, from a relative, from the school, so, where we start our investigation. And then in the pink is when the child is placed into protective custody by law enforcement. It could be the hospital. Hospitals have the authority to put a hold on them, so they would not release the child to a parent until we come, and then we would have to get a court order to be able to continue that process of not releasing the child to their parent. So then we'll have the shelter care hearing again within 72 hours, and I'll break that down a little bit for you as well. Then we have a very short hearing every 30 days. So again, a shelter care hearing, if there's a shelter care designation, this is where it gets kind of technical, right? Shelter care means the child has been removed from their parents. We can still get court intervention at this point without the child being removed from the home, then we would give it a totally different term, and we would call it an in-home pre-fact finding. Um, but it's still, we'll kind of parcel that out a little bit. But what I do want to say is when a child has been removed from their parents, um, that authority from the court is only good for 30 days. So we're going to have a very short hearing every 30 days where we have to go over that information again in terms of presenting to the court why it's still acceptable to impede the parent's legal rights by removing their child. Then our next set of hearings, we have a fact-finding hearing. So that's our dependency fact-finding. And the disposition is at usually around the same time. And I'll talk a little bit more about what those are. But those are our two big hearings where the judges are making very significant decisions, right, about whether or not the child can safely remain in the home with the parent. And then the second is deciding on if they're actually dependent of the state, and that triggers a whole lot more interventions and requirements. And then you'll see on here we have timeline for what we call review hearings or permanency planning hearings. And those, happen generally every 6 months. In each county, it's a little bit different, only because of court schedules and court availability. And I'll talk about why they don't always happen on time. But I know this can be frustrating for a lot of, maybe most or all relatives and kinship and foster parents, because you'll see this brochure often that has these timelines and it talks about what the law says, right? We're supposed to have this fact-finding hearing within 75 days of when the state initially seeks a ruling of dependency. And the reality is it just doesn't happen. And I'll share some reasons for that. But I just wanted to at least put this um, timeline, I guess, up for you to see, because it gets used in a lot of other examples and a lot of other trainings, or you may have been given a copy. And so again, if you have real specific questions about these, please make a note, and you can interrupt and ask me now or at the end. I'm trying to, again, not get too into the weeds of some of these things, but I also want to make sure you get all of your questions answered. So don't be afraid to ask me to break these down for you a little bit more.
Katie, there is a question.
Okay, great.
Is the petition that is submitted obtainable?
Obtainable by whom?
I'm assuming the care provider.
They are, uh, I mean, maybe later through like a public records request, but otherwise, no, it's not part of the information, um, that would be provided to you. It would definitely be, um, protected by confidentiality rules, because petitions are tough. And that it's basically taking every negative thing about a parent, and leaving out any of the positive things that they may be doing. And so, definitely talking about any substance use, any domestic violence. So unfortunately, that is protected information, and it would be pretty hard for you to obtain that. But if you have a relationship with the parent, I guess you could ask them. But I would think their attorney's going to say no. But we will talk about ways that you can get information, but all of the real specific nitty-gritty are not things that we're going to share, because it is very specific on dates and times and who and what they did. Okay, so a little bit more in depth again about what happens at these 72-hour hearings, right? So at this hearing, this is really the first time the parents are coming in front of the court. And they are appointed representation. Pretty much all of our parents, not literally all of them, but almost all of them will qualify for indigent resources. And so they would have a counsel appointed to them. The burden of proof for us at the state is pretty low. It is more likely than not. But again, we have a pretty long list of things that we have to prove. So we are not always successful in um, um, getting the judge to see our side of things. Um, the parents may agree at this point that they may agree to the shelter care order where the child is removed from them, and there's a visitation plan, and we talk about services that would be offered to them. Um, they may agree to the child being in the home, staying in the home, as long as they, again, sign releases of information, allow the social workers into the home, whatever is negotiated or is determined to be necessary for keeping the children safe. That is not the same thing as agreeing to the order of dependency. And again, these are legal terms, but it's kind of because there are different levels. I don't want to compare it to anything criminal because it's definitely not a criminal case, right? But the ultimate decision and hearing about court intervention comes later at that 75-day hearing or that dependency hearing. And part of why all of these hearings exist is we are impeding on parents' constitutional rights. Under the 14th Amendment, they have a legal right to parent their children in the way that they see fit. And so while our purview and our task and our heart is in keeping children safe, we butt up against um, legal rights, and these protections are there for a reason. And so that also kind of impacts, I guess, like everything. So I just wanted to at least throw out there as a reminder that because we all are, and rightly so, focused on keeping that child safe, but we have to also be mindful that in doing so, we are infringing on rights, and so that kind of dictates kind of some of these steps. So at that 72-hour hearing, again, that's when the court is going to determine, should the child be removed from the home, or can they safely stay at their parents, or did we just not meet our burden of proof? Therefore, the child is going to stay with their parents. The state can offer services. So we would offer them, we would pay for them, we would encourage them. They're completely voluntary for the parent. There is no repercussions or consequences if they do not engage, if they don't participate in services at that time. Um, some parents do. We have a lot of parents at this point that kind of go AWOL. They're really stressed out. They may have just had their children removed from them. They're struggling already with mental health and substance use disorder, and we don't see or hear for them for a little while during this period of time. Um, Others are a little bit more. Um, they're in a better place, maybe mentally, to engage and say they do want to try something. For some of them, maybe it is more of a, I don't want to use the word wake up call because that's too simplistic, but perhaps they have, they're just in a better state to realize that things really are serious now that they've lost their children, to a short-term intervention. Um, Let's see. So at this point, again, the court is going to review and decide the visitation plan for each parent. What is that going to look like? The state has the burden of proving that there must be supervision. So the default is that there would be no supervision. And then, so as opposed to like the default being, well, of course, we're going to have to supervise because why did we intervene if we didn't need to supervise? The assumption is this is short term. It's, maybe 3 hours at a time. We have to, as a state, prove why the parent would not be safe for that, 3 hour window, and go from there. Once this court order is signed by the judge, it will indicate whether or not the state has care, custody, and control of the child, and whether or not we can intervene with medical and educational needs of the child. parents will still, again, maintain their full legal rights, but it gives us the ability to enroll them in school and have a caregiver get them enrolled in the doctors and take them to see specialists or providers. But we're still kind of in a legal holding pattern because this is like a temporary decision. So as I said, if we have at this point met our burden of proof, if we've asked for the child to be removed from the parent's home, we're going to have to come back every 30 days and represent that same argument. And so this is now kind of in preparation for the bigger determination of dependency. Luann, is this making sense? Okay. Okay, so then we will have a dependency fact-finding trial. There's a much higher burden of proof for us, and so instead of it just being, more likely than not, it's more of a like 50.01% that we must meet. And so at that point, we have to prove that the child meets the legal definition of a dependent. And so we have an A, B, C, D, an A, B, C, and E that you can check. So whether a parent has abandoned their child, whether the child is abused, or the most common one is no parent capable, or we also have a distinction for children who've been sex trafficked by a parent. And so we have to select one or two or however many of those, and then as a state make the case that the child meets that definition. What's important to note here is by the time we go to this hearing, we're having to demonstrate that the danger and the imminent physical harm still exists. We can't just point back to a couple of months ago when we initially intervened. We have to be able to prove and demonstrate that this is still active, that this is still imminent. And so then again, at that point, we would have to demonstrate if out-of-home placement is necessary and meets the legal standard. So sometimes by the time we start out and then we finally get to this hearing, we may, again, when I say we, I'm talking about DCYF, not be able to meet that full burden. And so it could be that, again, it would be called an in-home dependency. So the child is in the home, but now there's still legal designation of them being dependent. So they are still under the custody, care and control of the state of Washington. And any services that are ordered at this time are court ordered. And so each parent is going to have a list of services that they're expected to complete. And they will be different for each parent on what they are. We oftentimes will have an agreement. So similar to, I guess, any other case, the state will put together what it's asking. If they're asking for out-of-home placement, they want the parent, let's say, to have a parenting and assessment and follow any recommendations, complete a substance use disorder assessment and follow any recommendations, mental health therapy, maybe working with a domestic violence provider, any of those. And then again, there's either some negotiation between attorneys or ultimately the judge is going to make the decision on what is necessary to try and remedy those parental deficiencies. We may have one parent who is in agreement with their section and another parent who isn't, and that's fairly typical. Maybe not fairly typical, but that happens. So there may be a trial, and at the trial there will be witnesses. It could last multiple days. Sometimes it's 2 days, 1 week, and then you have to wait a few more weeks until you can get in front of the judge again. So these can be pretty lengthy. It's pretty significant to have a finding of dependency. It goes on your record. So that is something then for parents depending on what their jobs are, if they work with vulnerable populations, that may prevent them from having specific jobs in the future. So it's pretty significant. And even a step beyond a finding of abuse or neglect, which happens again at the beginning. I will say, I showed you that timeline where it says this hearing is supposed to happen within 75 days of when we file the petition. And that's a federal timeline that says that we're supposed to meet that. I didn't have time to look at the percentages, but I would say maybe generously 50% of the time we're meeting those. And I'll talk about why that is that we are not. But unfortunately, this is a big reason why this whole process moves very slowly. Okay, so I showed you also that there are ongoing hearings. There are so many hearings. So again, part of the point of, again, just from the court perspective, right? Not talking about the well-being of the child. That's a different workshop. But this one, the court's really focusing on, they tend to focus mostly on the parents and how and what the parents are doing. There's a little bit of talk, of course, and discussion on the child, but because the parents are the one being evaluated to see if the family can be put safely together. The court hearings tend to focus on the parents as well as the state. So if you attend and you feel like they're not talking about the child a whole lot, definitely bring that up and encourage more conversations about the child to kind of remind the judge that you're talking about a real person. I'm afraid to look behind me. But that would be why those are kind of where the focus is. So as you can see on the slide, the court's going to consider at every hearing, what is the current family time or visitation schedule, and what is the supervision level, and should that change? The court's not going to get into the weeds of like if it's Tuesday and Thursday from 9 to 4, they're just going to say these number of hours or this number of hours and these number of days. And then it's up to the social worker and the family to like do kind of the nitty-gritty. They're going to look at the parents' level of compliance and progress in their court-ordered services. And those are broken down. So again, we look at each parent separately, and then we're looking at, you can be in compliance. Maybe you are showing up to your therapy sessions, but the therapist is reporting you're not talking, you're not engaging, you're not showing any demonstration of having any I don't know, breakthroughs or ability, reflection and stuff. And so at that point, we might just be saying, okay, well, they are in compliance, but they're not making any progress. Or you may say there is partial compliance. Maybe they're doing 2 of the court-ordered services, but they're not doing 4. And so, because again, it's a court process and a legal process, these will be argued between the attorneys because, of course, the parents' attorneys want it to show that their client is doing all of the things. What I do also want to say about services is ultimately what the state and the court is looking for is behavior change. And so we have examples of parents who may not complete some of their services and still successfully reunify with their parent or with their child because they have demonstrated for a considerable period of time that they have made changes. So it does get complicated because we are measuring their progress in compliance, and the court is looking at that, and that comes into play later if we're looking at potentially terminating the parental rights. Then we're going to look at like the history and the pattern of the engagement of the parent in these things. But there again will be times where the parent didn't engage in specific parts of those court-ordered services, but they still made the behavior change that allowed the family to be successfully reunified. the court's also going to be putting DCRF under the microscope and looking at whether or not we made sufficient efforts to reunify the children. And I'm going to probably start moving a little faster, huh? Any motions filed by the parties. And then they're going to hear from the parties to the case as well as the caregivers. So they're pretty standard hearings. Usually the only thing that makes it really interesting is if there's a lot of arguments between the attorneys. Um, Okay, so I'm going to quickly run through like, okay, so who are parties to the case? And parties refer to people who are, officially involved in the court hearing. They have not only obligations and rights, or they have, not only rights, but they have obligations. And so the obligations would be participating in the court directives, following court orders, and then they have rights, including the right to counsel, right to information pertaining to their case. So very quickly, we'll shoot through who are these. So the parents, obviously, each parent is going to be appointed an attorney. They will not have the same attorney unless they hire one. And the idea being that uh, the interests of each parent may not align, especially if they're not married and living together, or perhaps they are married and living together, but it makes, one parent might be the safe one for reunification and the other one may not. These are independent contractors with the State Office of Public Defense. They are expected to zealously represent their clients' stated interests and legal rights. And so, um, they are going to um, fight for that baseline. And so even if they don't have contact with the parent, they still are going to be able to provide good representation, or they should be able to, just based on what the rights of that parents are, and all parents would be. And so they're also there to explain and protect the parent's legal rights. So going over paperwork with them, making sure the parent understands the information. Um, and some attorneys will have very regular contact and communication with their client, and others not so much. And that can be very challenging and frustrating for parents if they want to engage with their attorney, and also frustrating for the attorney if they can't get a hold of their client. Oops, sorry. Parents are highly encouraged to attend court, but it's not required of them because their attorney would be there and speaking for them. And not showing up in court is not held against them. It's definitely beneficial for them to be there to hear, but it can also be really hard and challenging because if they're struggling, they're going to be talked about and put under the microscope. And it's very intimidating. So we very often don't see parents there, or perhaps a parent is doing fairly well and they're working and or they're in their therapy sessions. So there are a lot of reasons that parents would not come to court. But again, their compliance and progress is going to be graded with each hearing. The children also have support and representation. So they are going to have a child advocate or guardian ad litem, whose role is to advocate for what is called the best interests of the child. And so that is a hard to define, I think, best interest, but again, they're really looking at like what is, knowing each individual child and what's going to be best for them, and not their opinion of what is best just based on their personal values or ethics. They're really required to talk to family members, talk to the caregivers, talk to the parents, talk to the school, spend time with the child, know the child well enough to really understand what is going to be the best thing for them. They do have to go through training. They may be a trained volunteer, or they could be a paid staff. It just kind of depends on the county. Advocates will often advocate, or the GAL may have the entire sibling group, or they may not, but a lot of times that's pretty typical. And they are expected to write a report for the court for each hearing, and or well, most of the time they're supposed to have a written report, but they may also provide some oral communication in there. So if you are a caregiver, you'll most likely be hearing from a child advocate, again, CASA, guardian ad litem, but they all have that same role. We now have a lot of children with representation from an attorney. Um, at present, every child 12 and older will have one. Some counties are already funded to move that to 8 and up. And then we also have exceptions of if the child is legally free for 6 months, they would get an attorney, or when a termination petition is filed. So it depends on where you live, what age the child would have an attorney. They have a very different role. Their role is to represent the stated interest of the child, so similar to the attorney for the parents. But given that's not always possibility, just with development, they would represent the legal interests of the child. And generally speaking, the legal interests of the child look at being with their family. So that's often what they're going to argue. But if the child is able to make statements about their placement or where they want to be, then that's what the attorney would argue. They are also contractors with the state agency, the Office of Civil Legal Aid. I put a hyperlink in here. So if you're curious and want to learn more information about what an attorney for a youth is expected to do, what their training is, what that stated interest or legal interest would look like, you can go and check that out on the Office of Civil Legal Aid. The other thing is, again, if you're the caregiver, you may have an attorney who won't talk to you at all except to connect with the child. Because again, the child is their client. They're considered, you know, that they are going to follow the same rules of confidentiality, and that is simply a them conversation. Others may ask you more questions, but again, they're not going to be able to give you very much information, and I know that that can often be frustrating. They're not there to be the legal advocate for the caregiver. So it's really about, again, what that child wants or what the legal right of the child is. And I will say that we have some great youth attorneys or attorneys for youth, and some other ones that are still getting into their groove, just because it's a whole different ballgame to represent maybe a 3-year-old or a nonverbal autistic 12-year-old, or a teenager who just wants to live with their boyfriend. Real quickly, social worker, right? So their role is to represent the state's position in court. Or I'm sorry, the attorney general is. So the state is represented by the assistant attorney general, who does most of the speaking in court, is there to not only represent our position, but protect us from liability. The social worker is going to write a report to the court before each case, and provide an assessment of each parent and the child. So again, we would be making recommendations on compliance and progress for each parent, as well as recommendations for visitation, what we call the permanency plan, right? So looking at over each period of time, are we still on track for reunification? What do we think that's looking like? Or are we at a point where we think we need to be more seriously looking into and discussing guardianship or termination of parental rights and moving into an adoption? We have policy that we have to follow. So regardless of the social worker's personal opinions, they have to follow what the policy says. And last but definitely not least would be the tribal community. Anytime we have a child who we would designate as reason to know, so that's a legal term, is reason to know that they may have Native American or Alaskan Indian ancestry, we have to work with them as if they are a member of a tribe. And that can be anything from, I think maybe my grandma one time said we had some tribal ancestry, and it could be absolutely that vague, to, oh yes, my father is a registered member of the Chippewa tribe in Oklahoma. So again, as kinship, you may be asked these questions multiple times. And again, legally, we have to do very active efforts in learning and understanding if there are any tribal connections, because our Native American and Alaskan Indian children have additional rights and protections when they're subjected to a dependency process. So the tribes are invited to what's called intervene, and it's up to them. They get to decide how much they want to participate in these proceedings. In some cases, they may take over, and it would fully extract this from our court and move into their court system. Generally speaking, they will appoint an attorney and a representative who would continue to monitor the case, provide support kind of in a case management role. And again, they would have an attorney who would be there to represent the legal interests of the tribe. So not the child specifically, but for the whole, but as the tribe and what their legal interest is. And then we will also sometimes see a qualified expert witness, and that is someone, again, just for those extra protections for our tribal children. This would be a tribal member who is coming and giving their expert opinion to the court on if the state is doing enough to try and support this family. Who are not parties to the case: foster parents, relatives, visitation providers, school personnel, non-dependent siblings, pre-adoptive caregivers. And why is that important to know? It's just really a reminder that these are family matters, they are legal matters, and the party status, again, with it has obligations and rights that go along with it. And so very important to everything. They just rights and obligations that being a party to the case would. Okay. So you will find it very frustrating. The information you receive is going to be very limited. Full petition. You're not going to receive the entire report to court. You will receive generally about a page or so, because you have a right as a caregiver to information about the child, but not the parent. So some other ways that you can get the information would be going to court. Each county is going to have their own rules on if you have to be there in person or if you can join via Zoom. So you'll want to check with your social workers on what those rules are. There are they used to be called family team decision-making meetings, but now they're youth and family meetings. So that is another opportunity for you to hear how things are going in the case. You will be asked to share about the child if the child is in your home. The other thing about those meetings is the parents have to give their consent for anyone who is not a party to the case to stay and hear their personal information. And so there may be times that you attend one of these meetings, you share an update on how the child or children are doing, and then you may be asked to leave if they're not willing to let you hear. Other parents are totally fine with that, and then you're able to kind of hear how things are going and help work on a plan to support the parents. So court is really another, like I said, a good opportunity to hear what's going on, because you would be able to hear all of the information. And if you aren't able to go to court, the social worker can't tell you what happened. So showing up is something that's allowed, and that's really like your best opportunity for more details that you might be interested in. You will have, and I sent it to Luann, so you'll have that. It's also available online. The opportunity to complete a caregiver's report to the court so that you can share information with them. That would be completed, I would say, as early as you can, even up to 3 weeks ahead of time, so that you can get it to the social worker and they can make sure it gets filed with the court before the hearing. It's also really great. Then make sure you let the social worker know and ask them to also tell attorney, just so that the judge knows that you're there and can invite you to provide updates to the court. And then again, you can share information in these meetings, of course, anytime you're meeting with the social worker. Okay, couple, and then we'll open up the floor. So why is this taking so long, right? We have this timeline, we have federal timelines that say we're supposed to be moving things. Just it doesn't. And Washington, honestly, scheduling the parties as now that we have attorneys for youth, if there could be 8 attorneys. And so getting everyone's schedules together, getting a courtroom together, makes it challenging. Attorneys are not always in contact with their clients. Parents can be hard to get a hold of, or vice versa. There may also be statements or representations made to the judge. Oh, we just need more time. Then I think we can come to an agreement and we won't have to have this trial. And that can happen. And then something derails it, and then something derails it. So those are some very frustrating reasons for continuances. The other thing is we have adherences to policy and law. And so there are certain things that have to be completed before you can take the next step. And so if we get to, we're at year 3 and we're getting ready to move towards termination of parental rights, and then someone realizes, oops, we forgot to do X, Y, or Z, then that's going to put a pretty large delay in something. The paperwork itself is lengthy and complicated, and relies on multiple parties completing different sections. None of these are great reasons or excuses that, satisfy any of us for why it's taking very long, but I wanted to at least give you some reasons. We're trying to do better, at least here in Pierce and Kitsap County, of getting documentation on each order. Because every time the judge has to agree to let the hearing be delayed, that continuance. And there isn't usually very good records of why. So that's something we're definitely trying to work on, at least here, so that we, is it the same attorney who keeps going on vacation when they are supposed to be in trial? Is it that we don't have enough courtrooms or judges available? Are we being too nice time when we should just hold their feet to the fire? So unfortunately, we don't have super all of the reasons. So that's my not real great answer for that. Title I guardianship, if there are more questions about this, we can definitely talk further, but this is another question that comes up a lot. And I also put in a hyperlink on here to another training that was given on comparing the 2 different types of legal guardianship. But I wanted to just at least put this out there so that, again, if you have questions, we can talk about them, because there are definitely pros and cons. Title 11 guardianship is done without DCYF intervention. And so there are times when kinship caregivers will be wondering if they should do that, so that the department doesn't file a dependency petition. Sometimes kinship and relatives feel like maybe they've been pressured to file for one of these, or there's a family response of, oh my gosh, I don't want my grandchild to go into foster care, so we should do this. And I really just want to at least put out there that there's a lot of nuance, and so you definitely want to make a really good and informed decision. DCYF is not able to help you with the paperwork, but can provide you with information and resources, so you can make a decision as a family. Once the dependency petition has been filed, once the department has initiated that, it's a lot harder for a family to say, actually, we want to do this on our own. We want to file for guardianship and have the state stay out of it. And it just gets a lot more complicated. But again, if that's what folks want to talk about, then we absolutely can. And again, there's a good breakdown on of slides on that link that I'll have Luann send you. So again, why isn't the state following federal timelines? A lot of it is again because we can't do X until we've done L, and somebody forgot to do C. And so that happens a lot. We have rules and laws about notifying parents. And so that's one thing that trips us up a lot is if we can't find a parent, and we're expected to have made efforts over, Facebook and sending letters to the last 12 known addresses and driving by parks and all these rules before you're allowed to publish in a newspaper. And so if we haven't done everything, or you misspell somebody's name wrong, then now you have to kind of restart over again. It often comes up, feels like parents are getting so many chances. Some of that, again, ties back to their constitutional rights to parents. Some of it is judge's discretion. They may say, well, yes, the parent has been absent for the last 2 years, and we're moving towards termination, but oh, now they're here and they've signed up to go to inpatient treatment next week. So we're going to give them another opportunity, right? And so that could just be the judge's discretion. The other question is, should I hire an attorney if I feel like things aren't moving fast enough? I cannot give legal advice. However, as a non-party to the case, hiring an attorney is not likely to get you anywhere because you have no legal right to intervene in the case. So if you had an attorney, they can't bring anything in front of the judge because you don't have that legal standing. You could, again, get legal advice from an attorney, but they're not going to be able to participate in any of these proceedings. If you have grievances at any point, if there is a social worker that you're working with, you can talk to their supervisor, and then the person above them would be the area administrator. If you have concerns or issues, kind of just in general with DCYF, or you think what we've done is improper, inappropriate, you can always reach out to the State Family and Children's Ombudsman. So I put the link on there too, or you can just Google that. And they have a form for how you can reach out to them. And then the biggest thing too, I would always recommend is reach out to your legislative representative. The House of Representatives or your Senate, they're the ones that make the laws that DCYF has to follow. And so it's really important to let them know how the current laws are impacting your family, and your ability to support the children or the parents, depending on kind of where you land. But that's really the best. I mean, it's not the best because it's not going to, make immediate change, but they're the ones that are really kind of driving the bus here. I'm going to stop sharing my screen here in a second so you can get to questions and I can see folks' faces. But you will also have my contact information. Like I said, these slides are not DCYF product, but this is my job as a legal liaison to help. I mean, again, primarily working with social workers in the court system, but I have a very good understanding of how all of this works, what kinship providers are going through. So please feel free to capture my information, or Luann will send this out to you as well. I'm gonna stop sharing. Okay.